The reason why Meta was fined by the EU for violating data privacy laws is that it unlawfully transferred the personal data of Facebook users in the EU to the US. This exposed their data to US surveillance programs that could violate their privacy rights. The EU courts found that Meta did not have a valid legal basis for these data transfers and that it did not protect the data adequately. The EU has strict data protection rules under the General Data Protection Regulation, GDPR, and the e-Privacy Directive. These rules require companies to obtain users' consent for processing their personal data and to ensure that their data is only transferred to countries that offer an equivalent level of protection. Meta relied on a transatlantic pact called the Privacy Shield to transfer Facebook users' data to the US. The Privacy Shield was a framework that allowed companies to certify that they complied with EU data protection standards. However, in 2020, the EU's top court invalidated the Privacy Shield, following a legal challenge by Austrian lawyer Max Schrems. Schrems argued that the Privacy Shield did not protect EU citizens' data from being accessed by US intelligence agencies, such as the NSA and the FBI. He cited the revelations by whistleblower Edward Snowden in 2013, who exposed the mass surveillance programs of the US government. The court agreed with Schrems and ruled that the Privacy Shield did not offer sufficient safeguards for EU data subjects. Meta continued to transfer Facebook users' data to the US after the Privacy Shield was struck down, using another legal mechanism called Standard Contractual Clauses, SCCs. SCCs are agreements between data exporters and importers that bind them to respect EU data protection rules. However, the court also said that SCCs are not enough by themselves and that companies must assess whether the destination country offers adequate protection for EU data. Meta failed to conduct such an assessment and did not inform users about the risks of transferring their data to the US. It also required users to consent to personalized and targeted advertisements, which was not necessary for providing its services. This violated the GDPR principle of data minimization, which states that companies should only collect and process as much data as needed for their purposes. The Irish Data Protection Commission, DPC, which is Meta's lead privacy regulator in the EU, investigated Meta's data transfers and found that it breached several provisions of the GDPR and the e-Privacy Directive. It fined Meta a total of $1.3 billion, which is the largest fine ever imposed by an EU data regulator. It also ordered Meta to stop transferring Facebook users' data to the US within 5 months, or face further sanctions. Meta has appealed against the decision and said that it will continue to transfer data to the US until a new agreement between the EU and the US is reached. The EU and the US are currently negotiating a new framework for data transfers, which could be finalized by October. However, it is unclear whether this framework will address the concerns raised by Schrems and the court about US surveillance laws. Meta's data transfers are crucial for its business model, which relies on collecting and analyzing large amounts of personal data from its users to deliver targeted ads. If Meta has to stop transferring data to the US, it could lose a significant source of revenue and face competitive disadvantages. It could also affect its other platforms, such as Instagram and WhatsApp, which also transfer data to the US. Meta's fine and order are a landmark case for EU data protection law and a major challenge for Meta's global operations. They show that the EU is serious about enforcing its privacy rules and protecting its citizens' rights in the digital age. They also raise questions about how Meta will comply with different legal regimes around the world and how it will balance its commercial interests with its social responsibilities.